The applicant, Mr. Barger, will be seeking an order that certain evidence be excluded from trial on the grounds that it is inadmissible, or in the alternative, that Your Honour exercise your discretion not to admit the evidence pursuant to the public policy discretion provided for in Ireland and Bunny and Cross. Firstly, Your Honour, my submissions as to admissibility. Mr. Barger has been charged with one count of assaulting a police and one count of possession of a thing used to play an unlawful game. The relevance of the certain evidence to each charge will be examined accordingly. Pursuant to section 341B of the Criminal Code, any person who unlawfully assaults, resists, or willfully obstructs a police officer while acting in the execution of the officer's duties is guilty of a crime. The certain evidence in question is the backpack and its contents, namely the two-up equipment. This is real evidence. By applying the relevancy test used by Justice Gleeson in Goldsmith and Sandilands at 2, the evidence in question is not sufficiently relevant to the main fact in issue. The mere presence of the backpack and the two-up equipment within Mr. Barger's car do not satisfy the elements of the assault offence, and in turn do not rationally affect the probability that Mr. Barger is guilty of assaulting Constable Tamsin. Furthermore, the possession of unlawful gambling equipment could constitute evidence which paints a picture of general bad character, which could affect the jury's decision regarding Mr. Barger's assault charge. The decision in Antward and the Crown was that evidence of such nature is inadmissible. Therefore, Your Honour, I submit that the backpack and its contents are not relevant to the assault offence and thus are inadmissible at trial in relation to the assault offence. With regard to the second charge, section 233 of the Criminal Code sets out that a person who possesses gaming equipment that has been used or is intended to be used for playing an unlawful game commits an offence. Again, the real evidence is the backpack and the two-up equipment within, which were found in Mr. Barger's car. However, by applying the relevancy test from Sandilands, the backpack itself does not appear to be sufficiently relevant to section 233 offence. The fact that Mr. Barger was in possession of the backpack itself does not rationally affect the probability that he had used or had intended to use the two-up equipment for an unlawful purpose. The relevancy test can again be applied to the two-up gear found within the bag. Though section 233 of the Act identifies implements for playing two-up as an example of gaming equipment, the mere presence of the equipment in the car alone does not make it more probable that the equipment had been used or was intended to be used by Mr. Barger in an unlawful manner. Therefore, Your Honour, I submit that the backpack and its contents are inadmissible at trial in relation to the possession of unlawful gaming equipment offence. If Your Honour were to find that the evidence is admissible as a matter of law, I now turn to submissions in relation to the public policy discretion. As was held in Bunny and Cross at 78, certain evidence should be excluded if unlawfully obtained through the blatant disregard of the law by empowered law enforcers. This was primarily because to admit such evidence at trial poses a significant threat to the quote-unquote legal structure of our society and the dignity of the administration of criminal justice. This case also outlines several factors which can be effectively used to inform a decision to exercise public policy discretion. Firstly, consideration must be made as to whether Constable Tamsin's conduct was a genuine mistake or a deliberate breach of law. The section 31 of the Police Powers and Responsibilities Act provides that a police officer may search a vehicle without a warrant given a prescribed circumstance. Section 32 of the Act provides that the prescribed circumstance can include when a driver or passenger of a vehicle is committing an offence against Section 10C of the Summary of Offences Act. Subsection 2 states that a person who is in the vehicle that is in a public place must not wear or carry a prohibited item that can be seen from the public place. The Buzzcocks badge and 1% symbol on Mr. Barger's shirt do not appear to be in association with an identified organisation, and thus the shirt is not a prohibited item under Section 173EA of the Liquor Act. Therefore, Constable Tamsin appears to have made a genuine mistake in assuming Mr. Barger's shirt was associated with the identified organisation, the Buzzards. However, Mr. Barger made Constable Tamsin aware of his mistake after being pulled over, and despite the fact that Mr. Barger was not wearing a prohibited item, Constable Tamsin proceeded to search the vehicle without a warrant, which constitutes a deliberate breach of law. The purpose of the breach statute, namely Section 31 of the PPRA, is to allow police officers to search a vehicle without a warrant given a prescribed circumstance, and to ensure that police do not blatantly disregard the requirement for a search warrant prior to searching the vehicle. Because Constable Tamsin proceeded to search the vehicle despite being made aware of the fact that Mr. Barger was not wearing a prohibited item, the circumstance was not a prescribed circumstance. Thus, the evidence obtained from the search was unlawfully obtained. Secondly, consideration must be made as to whether Constable Tamsin could have complied with the law. The backpack and tool equipment are non-perishable items, and there were no apparent pressing circumstances on the facts that could have rendered the evidence unobtainable. Therefore, it appears that Constable Tamsin has cut corners out of convenience and could have taken appropriate steps to apply the law by potentially telephoning a colleague at the police station to obtain a warrant to search the car. As was held by Justice Lyons in the Crown and Day and Anor, if a police officer could have obtained a warrant under the circumstances but proceeded to unlawfully obtain evidence without a warrant, discretion should be exercised to exclude such evidence. Her Honour also suggested that it is in the public's best interest for such evidence to be excluded as a means of ensuring law enforcers do not quote-unquote flaunt the law. Finally, I will make reference to the gravity of the charges. Though Mr. Barger has been charged with the serious offence of assaulting a police officer, the evidence lacks relevance to the assault offence, and so the gravity of the offence should not impact the admissibility of the evidence in question. Therefore, the charge regarding Mr. Barger's possession of the tool equipment is not a serious offence. Therefore, Your Honour, I respectfully submit that you should exercise your public policy discretion to exclude the backpack and tool equipment, as both have been unlawfully obtained. Unless there's anything else I can assist you with, Your Honour, those are the applicant's submissions.